quickly run through the facts of the case. The petitioner, a UK company, was engaged in the business of insurance and was registered as an FII sub-account with SEBI. Basically, the petitioner, in addition to the insurance business, was also engaged in the business of making portfolio investments. What the SEC did was that they went to the Advanced Ruling Authority and took an advance ruling to the effect that these purchase and sale of shares were business profits. Now the difference basically these things make to a non-resident is that while capital gains is taxable, irrespective of whether or not the person has a taxable presence in India and subject to the provisions of the tax treaty, in case you have a business profits, but you do not have what is called a permanent establishment or some kind of a physical taxable presence in India, which could be through a fixed place of business or through an agent who acts on behalf of the non-resident, the profits are not taxable in India. So, what the Prudential did was that they obtained an advance ruling from the AAR which stated that your profits are business profits, and because you do not have a permanent establishment in India, you cannot, or you rather are not supposed to pay any taxes in India on the profits that you derive from such purchase and sale of shares. Now, as I said, this ruling was binding on the assessing officer and the Commissioner of Income Tax. So what the AO did of accounts, or rather the income tax returns filed by the assessee for 2 tax years, which was 2004, 5 and 5-6, and issued favorable order to the effect that such income was not liable to tax in view of the fact that the taxpayer did not have a permanent establishment in India. So what happened thereafter was that there was a subsequent ruling of the AAR in the case of Fidelity, wherein it was held that the profits derived from the purchase and sale of securities, or rather the equities, is capital gains and not chargeable to tax. So now we had 2 rulings, one in the case of the assessee, which was Prudential, and then thereafter there was a second ruling in the case of Fidelity, wherein it was held that these profits are basically your capital gains and which are chargeable to tax in India. Now what the Commissioner of Income Tax, which is the second level appellate authority in India, did was that he relied on the subsequent ruling of Fidelity, and what he held was that whatever profits and gains have been derived by Prudential are chargeable to income tax, and therefore he had set aside the assessment order for tax year 05 and 06 respectively. So now what was the issue before the Bombay High Court? What the assessee did was basically that it filed a writ petition against the action of the Commissioner of Income Tax to the Bombay High Court. And what was the issue before the Bombay High Court? The issue was that whether in case there is a subsequent ruling of the AAR in another applicant's case, can that give the right to the Commissioner of Income Tax, or for that matter maybe the AO, to revise the ruling of the assessee, which was binding on him, on the assessing officer, as well as the Commissioner of Income Tax. Moving on to what the case of the appellant was, or rather the petitioner's contention were, the first contention of the petitioner was that whenever a ruling of the AAR is given, that is binding on the assessee, that is himself, the assessing officer, and the Commissioner of Income Tax, which are all subordinate to the AAR, and therefore, in respect of the applicant and the said transaction, the assessing officer or the CIT appeal cannot take a contrary view. So, what happens is that whatever is the ruling of the AAR, that is binding on these 2 tax authorities. The second contention of the petitioner was that an AAR is binding as long as there is no change in the law. So today, if the AAR has given a ruling that the profits arising in the case of Prudential are business profits, then unless and until there is a specific change in the law, which could be either the domestic tax law or the relevant tax treaty, saying that any profits and gains arising on securities are chargeable to income tax, the tax authorities do not have a right to tax the transaction differently. So in present case, there was no change in law, and therefore the ruling of the AAR was binding on these 2 levels of tax authority. The third argument was that the Commissioner of Income Tax cannot have recourse to Section 263 of the Act when the assessing officer has very rightly and as per the law done the assessment in his case. because there is no ground for a revision in this case. What has been done is correctly in accordance with the law, and therefore there is no revision which is required. The last contention of the assessee was that the ruling of the AAR in the case of fidelity is again something which is applicable to fidelity only. It is not a change in law which is applicable to each and everyone, and therefore it cannot constitute a law. So therefore what happens is that this ruling is not binding in case of the assessee who has already got an AAR ruling in his favor. So now what did the tax department have to say in this case? They basically said that if the Commissioner of Income Tax has exercised his right under section 263, which is the revisionary powers which are vested with the CIT, then that does not give the High Court a reason to exercise his judgment in respect of a writ that might be filed by the assessee. So if there's a case, then the first thing is that that case has to go to the tribunal, which has to go into all the facts and circumstances of the case, and then accordingly decide whether this income is in the nature of business profits or capital gain. Under such circumstances, there is no power vested with the High Court to evaluate this case. The next thing which the tax officer contended was that the circular of a Central Board of Direct Taxes. So what the tax authority said was that the CBDT has issued a circular in July 2007, wherein they have directed the authority officer, which is the assessing officer, to examine whether the shares are held by the assessee as business income or as a stock in trade. So depending on that thing, the assessing officer was supposed to verify whether these were held by the assessee as an investment or these were held by the assessee as stock in trade. Now, given the fact that the assessing officer did not go into this analysis, the CIT was well within his right to exercise his revisionary power and seek recourse to section 263. Now let us see basically what was the ruling of the High Court. The High Court went into detail in all the aspects of this thing, and what they pronounced was as under. They said that once the ruling has been given by the AAR, its binding effect cannot be displaced in accordance with the procedure which has been stipulated in the law. So what they say is that if the AAR has given a ruling that this is business profit, which is not taxable because there is no PE, then mere fact that there is a circular which is there that does not give a right to the Commissioner of Income Tax or the assessing officer for that matter to disregard that ruling based on this procedural aspect which is there. Second thing was, a subsequent ruling of the AAR, which in this case was fidelity, cannot displace the binding nature of the earlier ruling in the assessee's case. So when there is a ruling of the AAR which is given in a particular assessee's case, the fact that there is another ruling which may be against it cannot give the right. The next thing was that an assessment order which gives effect to a binding precedent, which is in this case the authority of advanced rulings judgment in the case of assessee, cannot be regarded as being erroneous. Now, in order to exercise the power under 263, what is mandatory is that the order passed by the assessing officer should be erroneous and it should be prejudicial to the interest of the tax office. So what the assessment order, or rather the High Court said was that in this case, the order of the assessing officer basically gave effect to a binding ruling in the case of the assessee, and that cannot by any means of imagination be held to be something which is incorrect or erroneous rather, or it adversely affects the tax office. And therefore, the revisionary power under 263 could not be exercised, and because the exercise of power itself was not proper, there should not be any obligation on the part of the company to pursue these. Accordingly, the High Court quashed the show cause notice issued under section 263 by the Commissioner and treated it as improper and therefore invalid, and therefore upheld that this ruling, which was there in assessee's own case, would have binding effect on the tax office. I hope you had an interesting learning here, and we look forward to many more sessions like this on a going forward basis. Thank you.